I'm Professor Mushtaq Hussain, and I teach political science and international relations here at BITS Law. I've done my PhD from the Jawaharlal Nehru University in New Delhi, and as part of my thesis, I've also spent a year as a research associate at the Bar Ilan University, which is close to Tel Aviv in Israel. That was because my focus in my PhD has been on the role of religion in international relations, the role that religion plays in conflict, with a specific focus on the Israeli-Palestinian conflict. So, Middle East is the specific area within international relations that I have. That's my domain expertise. But here at BITS Law, I primarily teach courses in Introduction to Political Science, Political Ideologies, then a core paper on Introduction to International Relations. And since we are a very new school, we are still designing elective courses, which means that in the third, fourth, and fifth year, I am planning to, still in the process of designing elective papers around law and diplomacy. So the topic that we have chosen for the webinar today comes straight out of the discussions I've had with domain experts on how to bring in international law and Indian foreign policy into a format which can be curated towards an elective paper for BA, BBA, LLB students at the undergrad level, essentially. So the discussions that I've had led me to a specific area within Indian foreign policy, which is the role that India has played since independence till now, as far as the international legal scenario is concerned. And can we say with a modicum of confidence that we are at a stage right now where our foreign policy, where our diplomacy is counted upon or is looked up to when it comes to either drawing up of international treaties or in the implementation of international treaties? Unfortunately, the answer to that question is a mixed bag of missed opportunities and certain successes as well. So the idea of this webinar, as I mentioned, emerged from those discussions about an elective paper. But what I intend to do in the next 30, 35 minutes, probably 30 minutes because of the technical glitch, is that I'll try to give you an overview of what role does an appreciation of international law plays in the foreign policy of any country, and then specifically the Indian state as well, Indian foreign policy as well. And then we'll look at how, with the help of a few examples, how an appreciation of international law can help a country like India promote its interests at the international arena. Now, just a bit of an introduction to begin with. Now, international law or an appreciation for international law is considered to be a sine qua non at the foreign policy level. This is something, to put it in very simple terms, what I'm trying to argue is that an appreciation for international law is considered to be one of the most essential aspects of the foreign policy of any country. But there are certain countries in the world which have a very close interaction, cooperation, and coordination to the point of integration between academia and diplomacy. The primary example in this case would be the US, the United States of America, where it is a common practice to look at experts from the academia who specialize in matters of international relations, international law, or any specific niche area of international law and include them in the administration, include them at the level of policy implementation. Whereas on the other end of the extreme is a country like India, where we have career diplomats, where we have diplomats who are recruited primarily through only one stream, which is the Union Public Service Commission. So what that means is that we hire generalists who might not have a grounding in international relations to begin with, and then we train them in the job. We train them while they are carrying out their responsibilities. It has its own merits, but it also has its demerits. When it comes to demerits, the problem that Indian foreign policy faces is that in our country, sometimes we don't have the kind of expertise that a lot of countries do when it comes to negotiating treaties. So in those scenarios, we have to hire international law experts, which sometimes come in only to help with very specific needs of international relations. As a professor in a law school, in an up and coming law school, that is good news for me, because I can then hope that some of my students, future students, would take a very keen interest in international law, finish their LLB, go on to specialize in international law, and probably one day help these career diplomats sustain, preserve, and promote international treaty negotiations, or promote India's interest in these treaty negotiations. I'll give you a very specific example. Uh, all of you must be aware of a country called Iran. It has been in news recently. Historically, Iran has been a very important source of oil imports for us, energy imports for us. It has also been a very important partner for India, especially when it has come to finding alternate routes for Indian exports to certain specific geographies, certain specific regions in the world. I'm specifically referring to Eastern Europe and Central Asia. Historically, during the colonial times, or even before that, during medieval times, there has been extensive evidence of trade between empires and states in India, as well as the empires and states of Iran and all the way to Central Asia. Most of this trade used to happen through the overland route, which would cross from India to present day Pakistan, present day Afghanistan, present day Iran, then the Central Asian states, and all the way to Eastern Europe. These routes were more or less shut off for us because of the partition which accompanied our independence. Since then, there has been a stream of thinking, a strategic thinking, that Iran could work as an alternate route for us, that we could export our products to Central Asia by using the sea lanes of communication from Western Indian ports to Iran, then the overland route from Iran all the way to Central Asia. So these are the two major streams or major focus of our relationship with Iran. Therefore, we have seen that from 1950s onwards, Iran has continuously been among the top three exporters of oil and gas to India. Or let me put it this way, Iran has been one of the top three destinations from where we import our oil and gas. At the same time, in the past 10 years, we have actually invested hundreds of millions of dollars to build infrastructure, transport infrastructure in Iran. We have built a port called the Bahar port, which was named by Iran after one of their historical figures. They named it the Shahid Beheshti port. And from there, we have built a highway that connects this port to Afghanistan. This was before the Taliban took over in Afghanistan, and the idea was that India would not be dependent on Pakistan for our exports to Afghanistan. And then there were plans to further connect these highways to more highways and railways all the way to Central Asia. We were also planning to use the inland water sources of the Caspian Sea. Now, all of this, there has been a lot of controversy, but all of this has effectively stopped because of American sanctions. America brought out a law, a domestic law in America called CAATSA, CAATSA, which stands for Countering America's Adversaries Through Sanctions Act. As the name suggests, it targets certain countries that America identifies as its enemies. And there are three states mentioned in that act. One is Iran, the other two are North Korea and Russia. And the idea was that America did not want these three countries to earn foreign currency through exports, whether and whatever type of exports they are. But the primary focus was on weapons exports and energy exports. So the idea was that if there is a third country which wants to trade with these three states, either import oil or weapons, then America would put sanctions on that country. The idea was that if a country such as India wants to import weapons from Russia, then America would put sanctions on India. Now, this is at a time when India was already promoting its relations with America, and the two countries were actually talking with each other at the level of strategic partners. So, what India was forced to do was actually request America to create an exception for India. And after a lot of behind the scenes diplomatic negotiations, America did give us the exception. We were allowed to import weapons from Russia, and we were also allowed to import a few oil and gas resources from Iran. However, if we had experts on international law in our Ministry of External Affairs, there is another stream of argument that we could have taken, and that is based in international law. The argument that international law is based on two primary pillars of strategic autonomy and sovereign independence. Strategic autonomy means that every country in the world has the independence and should have the independence to decide its foreign policy without any external interference. And the same can be said about sovereign independence as well, the ability to take decisions without any external interference. Even if America has created an exception for us, we had to request America. We are a sovereign nation at the international level, and so is America. So at least theoretically, the two countries are equal to each other. So is Iran. So if we have the freedom, or if we have the theoretical freedom, sovereign freedom to take our decisions, then America has no business in telling us who we can import our requirements from. The fact that we had to request America for an exceptional treatment under the CAATSA Act means that we have actually gone against international law, or to put it in practical terms, to put it very bluntly, we were forced to request, despite the fact that we claim to have sovereign independence. The reason why I bring up this example of Iranian oil imports and the effect of CAATSA on India's oil imports from Iran is the fact that our Indian foreign policy, the practitioners of our Indian foreign policy, the diplomats who are doing it, need a grounding in international law. This is just one example. There are multiple such examples from different areas, different fields of international law, areas which are assuming an increasing level of importance day by day, whether these are climate negotiations, whether these are negotiations related to WTO, and how India is constantly under pressure to reduce the amount of subsidies that India grants to groups of its citizens, whether they are farmers, whether they are the medium, small, and micro enterprises, entrepreneurs who have very small industries, in order to protect them from unfair competition, or any sort of deal that India, or any sort of economic policy that India wants to implement at a domestic level. The idea is that in all these negotiations, we need to have a grounding in international law. This is where one more important target of or objective of Indian foreign policy comes into picture. Over the last 2 decades, we have increasingly seen that the world is divided into two clear groups. One is the so-called developed countries, and the other is the so-called developing or underdeveloped countries. The first category, sometimes colloquially referred to as the global north, whereas the second category is referred to through the terminology of global south. The global south is effectively the majority of states, because the majority of countries in our world, out of the 193 members of the United Nations as well, are falling within the category of either developing or underdeveloped. And it's only close to 40 odd countries which clearly fall under the category of the developed countries. But we have seen that this minority of states, the so-called global north, dominates negotiations when it comes to international treaty talks, treaty diplomacy. And they invariably have been able to force their will upon the global south states. This is because of a plethora of reasons, numerous reasons, but one of the very important factors here is their grasp over international law and their expertise in negotiating international law, or let me put it this way, their expertise in negotiating the loopholes within international law. The only country which is from the global south, which has achieved a level of expertise in having the same kind of control over international law, is perhaps China. Now, interestingly, India is probably the only country which has a constitution with an article which clearly mentions a focus on international law. In the directive principles of state policy, which are part of our Indian constitution, we have an article, Article 51, which effectively talks about promoting international peace. But among the 4 subclauses, the third subclause talks about fostering an understanding and interest in international law. So there is a constitutional provision. Our founding fathers knew that for a newly independent country like India, An important part of our growth trajectory would also be that India becomes an active member of the international community. And this will only bring us results if the other countries which are part of the international scenario are also law abiding countries, just the way India was planning to be. And therefore, this particular article was included. In order to implement this article, our first government created an institution in our country called the ISIL, Indian Society of International Law. This is around the same time that China also established an organization with precisely the same name, the Chinese Society for International Law. That these two were modeled on the American Society for International Law in turn. So we have three states, America, China, and India, all of which have government institutions with more or less the same name: American Society for International Law, Indian Society for International Law, and the Chinese Society for International Law. But unfortunately, it's only the American and the Chinese societies for international law which are very active, to the point that the reports and the policy papers that they regularly publish are used internationally as a reference point for how their respective governments approach international law, how they approach international treaty negotiations. And we can also then read these reports to somewhat predict what would be the next step in any particular area of international law. So, to give you an example, China is engaged currently in a major controversy with its neighboring countries, specifically with Philippines, with Indonesia, with Malaysia, and Vietnam. There are other minor parties as well, but Malaysia and Philippines are the primary parties. And this controversy is about the contradictory territorial claims in the ocean called the South China Sea. The South China Sea is bordered on the north and northwest by China, but on the east and southeast, Philippines is there. And within the South China Sea, there are two major groups of coral islands. One is called the Spratly Islands, the other is called the, I've suddenly forgotten the name. Yeah, so one is called the Spratly Islands, and the other is called the Paracel Islands. Now, because of their nature, these are coral islands, which meant that these are essentially coral depth to coral growth. Now, coral growths are visible only during low tide, and they submerge during high tide. These are therefore technically non-permanent islands because you can't see them above the surface of the sea during high tides. What China did is that in order to substantiate its claim over the South China Sea, it sent its navy, surrounded these islands, and sent industrial ships, which are called dredgers, which dredged or picked up sand from the seabed, dumped it over the coral islands, raised their height by a few meters, and effectively created artificial islands. Not just that, after creating artificial islands, China established a military presence there. So it created airstrips, it created hangars, and stationed its air force there. It created jetties and stationed its navy there. It created air defense systems so that it could prevent any other country, whether it's the ship of any other country or the aircraft of any other country, to come anywhere close to those islands. And then turned around and said that, see, I have a presence here, so these belong to me. Philippines didn't agree and went to a court, an international court, a court which has been established legitimately through a United Nations agreement. That agreement is called UNCLOS, United Nations Convention on the Law of the Sea. Now, after years of negotiations and representations from all the sides, the Court of Arbitration under UNCLOS gave its judgment, and the judgment rejected Chinese claims and said that the South China Sea should be divided on the basis of territorial limits. That's a completely different debate. We are not going into that. But effectively, what I'm trying to say is that the Court of Arbitration under UNCLOS rejected Chinese claims. The reaction was, of course, the Ministry of Foreign Affairs in China countered that judgment, rejected UNCLOS, and even started saying that the Court of Arbitration in the first place had no jurisdiction over the matter. But a more solid, detailed analysis of that judgment came in the form of a report, a policy report, which ran into almost 550 pages. And this report was prepared by, as you might have guessed, the Chinese Society for International Law, the Chinese Society of International Law. So the point of this example was how government institutions should focus on international law, because these are crucial in justifying, in legitimizing, and in disseminating crucial information about why a particular country behaves in a particular manner at the international level. This is the only way we would probably be able to convince other countries about the legality of our judgments. Rather than depending on requests, rather than depending on behind the scenes negotiations, give and take, compromises, we need to have a foreign policy which is clearly rooted in international law, and not only rooted in international law, actually presents the Indian side to it. Unfortunately, the Indian Society of International Law is near defunct. It nowhere can be seen to have the same level of engagement with the Ministry of External Affairs or with the other international organizations the way the Chinese and the American societies do. So, what can we do in this sense? Of course, we can't force the government until unless there is a very clear constituency which is invested in it. That sort of a constituency will only emerge if we have experts in international. As of now, since 1950s till now, there have been a lot of Indian individuals who have achieved a status of respect at the international level. Most of these are lawyers. The biggest name is Justice Nagendra Singh, who was the first ever president of the International Court of Justice. But we also have people and experts from academia, such as Professor Bharat Chibni, Professor R.P. Anand, Professor Upendra Bakshi. These have been luminaries of the international law field, to the point that Professors Chimney and Professors Anand have actually gone ahead and helped the Secretary General of the United Nations in several areas, sometimes as legal experts, sometimes as heading committees, sometimes as being in charge of producing reports, which is a matter of great pride for us. But in the last few decades, we have seen that there has been a declining trend of interest in international law, which has started picking up again in the last 5 years, especially in the post-COVID era. Because of growing importance of areas such as AI, the lack of a global regulatory mechanism on AI, the fact that the government of India is also focusing on having a policy for AI, the fact that there was a major conference in India in November 2023, which led to the formation of an organization called the GPAI, the General Partnership in Artificial Intelligence. It released a statement called the New Delhi Declaration. And within it, 23 countries came together and said that they are going to create a partnership through which global AI can be promoted as well as regulated. There are a lot of legal loopholes there. Because of focuses like this, because of the focus on IP, because of the focus on climate negotiation, because of the focus on climate finance, these are all issues which are squarely in the middle of the emerging areas of international law. And that's why, as I mentioned in the beginning, this attempt at our institution to come up with elective courses in that, to come up at least with a major elective course which brings in these ideas. So when we talk about international law, it's a very broad area, but within international law, there are niche areas, specialized areas where you can focus, where we should focus, where lawyers have to focus if they want to contribute to the growth of India as a Vishwaguru, as we speak. So I'll stop here because I believe that I've taken up a lot of time. It's 6:40 already. I now open the floor for questions. I have a colleague of mine, Ms. Mrinalini, who is from our admissions team. So if you have any questions, please write in the chat box and then I can take up those questions. Thank you so much.
Thank you. So there's a chat box mentioned below. You can put in your questions and I can address it to Professor Mushtaq.
If you wish, you can also unmute yourself and ask a question. Any question?
For that, I think you'll have to raise your hand because then I can give you the permission to unmute yourself and then talk.
Let me also broaden this area. If you want to ask questions in general about Indian foreign policy or about international relations, international politics, please.
One question that is from UT Singh,
Okay.
wherein the question is, can you please tell about nuclear policy's relation with international foreign policy?
Okay, very interesting question. Now, at the international level, nuclear, anything to do with nuclear energy, including civilian energy or the unpopular growth of nuclear weapons. These are essentially governed by a very important international agreement which was signed in 1968 but came into effect in 1970, called the Nuclear Proliferation Act or the Nuclear Non-Proliferation Treaty, NPT. NPT says that at the time of signing, which was 1968, NPT says that the countries which have already developed nuclear weapons will be called nuclear weapon states. In 1968, there were 5 countries which had developed nuclear weapons, which are the US, the UK, Russia, China, and France. So NPT said that other than these 5 countries, it is prohibited, it is illegal for any other country to ever develop nuclear weapons. It went ahead and said that if any country wants to develop nuclear energy, we will help you. All you need to do is sign the NPT and commit yourself that you will never develop nuclear weapons. Then we will help you develop nuclear energy. It only verbally, in a very vague manner, also said that these 5 countries which have got nuclear weapons will think about giving up their nuclear weapons, meaning they will denuclearize. India took the lead among all countries in the world and said that this is an unfair treaty. If the treaty is asking every country in the world not to develop nuclear weapons, then at least there should be a time-bound manner in which these 5 states should also give up their nuclear weapons. That's the only way we will truly realize the dream of a nuclear weapons-free world. Otherwise, all this treaty does is to create a power imbalance. 5 countries which have nuclear weapons, they will remain powerful and they will prevent anybody else from becoming powerful by creating nuclear weapons. So NPT is the benchmark or the foundation for nuclear negotiations at the global level. India has not signed it, and therefore India did not receive international help when India was trying to build its nuclear energy policy, when it's nuclear, essentially it's nuclear energy field. Therefore, whatever we have done is completely indigenous. The only exception is the Kudankulam nuclear reactor in Chennai, which the Russians are building. They haven't given us technology. They are building. They'll take away whatever spent fuel is there. Effectively, what I'm trying to say in one line is this: international foreign policy is not able yet to democratize international nuclear policy. It is still dominated by countries which have the 5 countries which are recognized as nuclear weapon states. And the other states, there are 5 other states which have developed nuclear weapons, including Israel, including India, including Pakistan, including North Korea. And there is a suspicion that probably Iran is also very close to it. But those are countries which have not signed NPT. So there is a lot of mismatch. There is a lot of non-democratic practices in the nuclear arena. I hope that answers your question. Yeah.
Hello. So there's one more question by a student wherein so it says that what are the challenges to the international criminal justice considering the changes brought by the modern innovations?
First of all, when it comes to international criminal justice, we have a long way to go. We have an international criminal court. We have an international court of justice. Especially the ICC, the International Criminal Court, is at the pinnacle of international criminal justice. But it's not very effective because it is a result of a treaty negotiated with the help of the United Nations. And a lot of countries have not signed up to this treaty for the simple reason that countries do not want their citizens to be tried under the criminal laws at the international level. In other words, countries want that if their citizens are accused of a crime, then they should be tried and they should be prosecuted within their own territorial jurisdiction. Because of that, and that in itself becomes the biggest challenge. What happens in the case of transnational crimes, such as crimes related to human trafficking, international illegal migration, arms trafficking, or the crimes at the high seas? So let's say there is a Chinese naval, there is a Chinese boat which has committed an act, a criminal act in the high seas, which are not within the territorial waters of any country. So these are all gray areas. These are all loopholes where you don't have a clear answer, and these therefore become a challenge. Should we have laws which clearly aim to fix or address crime in the high seas? There has been one attempt. There has been a treaty called the proliferation. It's called the PFI, the proliferation. Uh, no, it's something else. Sorry. So the treaty is called Proliferation Protection Initiative, which specifically targets arms trafficking. And even that is very complicated. It says that if you have suspicion that arms are being trafficked in the international ocean, then the closest country which has signed this treaty can send its navy, its special forces, catch that ship, apprehend it, and bring it back to its port. And then the laws of that country where the ship has berthed, that that country's laws will apply. But a lot of countries, once again, have not signed this treaty because they say that this goes against sovereignty. So these are the type of challenges that are coming up at the international criminal trial level. I hope this answers the question. Can we move to the next one then?
Yeah. So the third question is by Bhuvan, wherein he's asking, do you know any case of criminal liability of legal persons for crimes under international law on domestic level?
Oh, yes. In fact, just before this, I mean, we don't have cases from India, but just before we started this webinar, I was reading this report in this new update which came in BBC. So if you follow BBC, you'll see that there is a huge emerging issue of illegal migration and human trafficking between France and UK across the English Channel. And 3 days back, there was a mishap there, an accident there, which led to the deaths of 5 people who were trying to illegally cross from France into UK. And the UK police, after its investigation, a very swift investigation, apprehended 2 people. One of them, 3 people, 2 of them are British citizens. The other person is actually French citizen. So a French citizen will now be tried and prosecuted under international legal treaties. In this case, the European treaties on prevention of human trafficking, but within Europe. So in the last 10 years, from 2014 till now, the biggest examples of prosecution at the international level for crime committed across borders are emerging from this area of human trafficking. There is a major migration. There's a human rights crisis happening right now, where hundreds of unaccounted migrants are dying in the Mediterranean Ocean, Mediterranean Sea because of these human traffickers. The other major cases are of arms trafficking, the illegal trafficking of arms. Other examples which are used, the closest example that comes from South Asia is related to a few arms traffickers who were using a particular place in Bangladesh, on the coast of Bangladesh, very close to Chittagong, called the Cox's Bazar. Cox's Bazar has been historically infamous as an illegal arms market. So, because of their activity there, a couple of Vietnamese and Thai people were prosecuted at the International Criminal Court. That's the closest to India, actually.
Okay, so there's one more question by Sri Ram, wherein he's saying, good evening. With an increase in geopolitical tensions and an increased divisions of countries into multiple blocks, will India's stand neutrality remain valid in the next 20 to 30 years? And can a situation arise whereby India will have to reevaluate its stand on neutrality?
Okay. Very good question. Let me think. 20 to 30 years is too long a time in international relations, actually. In the present scenario, things are changing on a monthly basis, if not weekly. So let me highlight something that happened in the past week. Maybe that could be sort of an answer to your question. All of us have seen how India was becoming closer and closer to the US, relying more and more on the US with a clear eye on China. So without actually saying this, that India is actually following this policy, there were very clear signs that India is relying a lot on help from America in countering growing Chinese pressures. Um, but there was a news item that came out yesterday, day before yesterday, and this was the growing. I think the headline in the Indian Express was that growing friendship between Russia and China is creating headaches for India. What does that mean? That while we are happy with the help that America gives, America has a very problematic reputation of abandoning its friends the moment it feels that its national interest is served. The most recent example was Afghanistan, where to minimize its own damage, the collateral damage to itself, it just abandoned the Afghan government. It had done the same in Vietnam. It has done the same in numerous cases. So India had constantly talked about neutrality while at the same time maintaining very good relations with both sides of the spectrum. Of course, not with China, but with Russia and with America. And India was able to very successfully utilize this stand of neutrality after Russia started its attack on Ukraine in February 2022. And in fact, the world was in a lot of ways thankful that there is a major democratic state like India, which is equally friendly with Ukraine, with Russia, with the West, including with the Americans. But this is a case where, to use a colloquial saying, that we don't have skin in the game. It doesn't affect us that deeply, that close to heart. Anything that China does is a very different matter. Anything that China does makes us sit up and take notice. So if China is exporting weapons to Russia, if Chinese-Russian relations are progressively becoming deeper, there is a real apprehension that we might lose one of the superpowers who has constantly had our back against China, which is Russia. That leaves us with an unhealthy reliance and dependence on America. And as I mentioned, America is not that dependable. It doesn't have an image of being a dependable ally. So, what will happen in 20, 30 years? I don't know. But even within the next 2 to 3 years, India will have to make sure that it plays its cards very well so that whether it is Russia, whether it is America, we should have at least one power on our side if China decides to be adventurous. I hope that answers your question.
Yeah. So there's one more question. Afreen Sheikh, what are the challenges to the international criminal justice considering the changes brought by modern innovations?
I think you've answered this question, but I didn't answer modern innovation. So
Yeah.
the emergence of dark internet, the emergence of cryptocurrency, AI, these are all modern inventions which are presenting serious legal challenges to law enforcement agencies, criminal justice system across the world. From the very obvious problems of jurisdiction, any crime which happens over the dark internet, how do you fix jurisdiction? Then the issue of jurisprudence. Which country gets the right to implement its laws when it comes to apprehension, when it comes to things like these? So there are a lot of these cases, these issues which are coming up because of modern technological innovations. This is in addition to what I talked about earlier as well.
Yeah. So one more question, Matthews. He's asked a question which is very long. In the context of Russia and Ukraine war, Russia and the West have imposed sanctions on each other. It affects the third parties which are not connected with the disputes. How do you look at the sanity of such sanctions? Also, now the West is talking about taking over Russia's assets, that is, goes beyond freezing the Russians' assets. Is it valid under the international law?
Okay, so the first part of your question.
Yeah.
In international law, sanctions are allowed only if there are countries which have signed a treaty and are not fulfilling their obligations. And these sanctions can be put by international organizations such as the United Nations. Within United Nations, the United Nations Security Council or the United Nations General Assembly, but primarily the UN Security Council. International law does not say either does not say anything about sanctions imposed by an independent country, an individual country, or indirectly there are certain treaties which indirectly hint that putting sanctions on another country is illegal, but it still happens. So what am I trying to say? That there is a clear gap between the letter and the spirit at the level of the international law. Even if there is international legal precedent of not looking at sanctions, especially economic sanction or any other type of sanction, diplomatic, military, in a strictly legal sense, the practice still exists. What does that tell us? That at the international level, while theoretically all countries are sovereign, all countries are equal to each other, it is an arena where power speaks, where might is right. So if you are, so what? Let me put it this way: because of the practical aspects, because of the practice, any country in the world can put sanctions on anybody else. So theoretically, a country which is very poor, so for example, a country such as, I don't want to take names from my immediate neighborhood, but let's say any country like North Korea or any country like Ethiopia in Africa, a poor economy, but for all practical purposes, even Ethiopia can put sanctions. Ethiopia can tell Iran that if you sell your oil to India, I will not import anything from you. This is my sanction on you. Ethiopia can do that. But will it be fruitful? No, because Iran will say, I don't earn anything from my exports to Ethiopia, but I can earn billions of dollars through my exports to India. So, of course, I will not accept Ethiopian sanctions, but replace Ethiopia with America and let's say that America tells India that if you import oil from Iran, you can't trade with me. Now, this will make India stand up and take notice because we get to lose a lot. We might import billions of dollars worth of oil from Iran, but we can find alternate sources for that. But if we lose the market, the both export and import market, the American market, that will harm our economy to a much greater extent. So this is the practical calculation that powerful economies rely upon, and they force weaker economies to follow their sanctions. Is it legal in international law? No. Not a categorical no, a conditional no. But does it happen? Very often. Why? Because at international level, might is right. If we want to change it, we need better treaties, which right now it's not happening. I hope that answers your question.
Question by Amrita. How does the coming together of the global south influence a new world order? In what way do you see India's power dynamic changing?
Okay. Um, the global south has a lot of negotiating power, that it has a lot of potential that it has not realized as of now. The primary reason for that is that the countries of the global south are not as unified as countries of the global north. The global north is light years ahead of us in terms of anticipating issues, anticipating problems, and creating structures where they can start thinking of answers to future problems right now. The global south has always been playing catch up. The only exceptions here is China to a large extent, and now to some extent India. So India can actually rally these global south countries around itself, convince them of its leadership, and use that to play a much larger role at the international level, which can which can serve two purposes. One, it can, because India has achieved a certain level of respect at international level. So when India speaks on behalf of the global south, there will be more countries who will pay a much closer attention. But at the same time, India can fulfill its own foreign policy objectives as well. One of the biggest objectives we have is to achieve a permanent seat in the UN Security Council with full veto powers. We can't have that until unless all the permanent members in the United Nations Security Council support us, and also a overwhelming majority of UN General Assembly. While of course you can say that China will never help us, but we are talking of the long-term future. So by playing the role of a leader of the global south, India can increase its presence, its heft, and the respect it has at the international level.
So question by Harshil Mehta. The US did impose sanctions on India in 1998 following India's nuclear test. These tests were seen as a breach of non-proliferation norm, and sanctions were a part of an international responses to discourage nuclear proliferations.
Yes. Okay. I thought this is just a statement. Is there
So
a
this is
question?
how he wants to, I guess, know more about it. I mean,
Okay. Yes, India has. I mean, and it has had a lot of practical implications on us. The reason why our space program was delayed by almost a decade is because of these international sanctions, no country in the world agreed to give us advanced technology such as the cryogenic engine. The cryogenic engine is used in rockets, but it can also be used to build long-range ballistic missile, intercontinental ballistic missile, and a lot of other factors as well. But while so first of all, let me address this. It will be wrong to accuse India of proliferation. Why? Because the definition of proliferation in itself has an element of cross-border transfer of technology. One country has to give the technological know-how or nuclear weapons or nuclear material or the technology to build nuclear bombs. We did not take that help from anyone. All of India's nuclear weapons program is indigenous, developed completely in-house domestically. So since we have not taken help from any other country and we have pledged never to give technology to any other country, India cannot be blamed of proliferation. And there is a growing international respect for India's position. The world, including America, now respect India's position. They know that India has a very solid principled stand because of which India is not going to sign the NPT. But at the same time, the world can rest assured, they can relax and they can assume in a very confident manner that India will never share its nuclear technology with anyone. Therefore, you see that India is the only country in the world which faced American sanctions in 1998, but within 5 years, in 2003, America offered us a civilian nuclear energy cooperation agreement as well. It's called the 123 agreement. This has never happened in the world that a global superpower is offering nuclear technology to a country which has not signed NPT. And this shows you how much the world has respected our stand on the nuclear issue. Just to give you one more example, the only country in the world which has suffered from nuclear attack is Japan. So Japanese public opinion, Japanese government is very, very sensitive to any country which does not sign NPT or which develops nuclear weapons. So when India developed nuclear weapons or tested the nuclear weapons, the second Pokhran test in 1998, there was a major debate within the Japanese parliament on whether to continue with giving India financial aid for infrastructure development. But they also respected our position on non-proliferation. And within 2 years, you see that there was a multi-billion-dollar investment in the form of the Delhi Metro project in our country. So all the countries in the world, they agree that they cannot blame India of proliferation.
So I hope Harshil has got the answer because I see him, he has raised his hand to get an answer for the statement. So Shivam has asked one question. The role of UN Security Council, permanent members, and the power of absolute veto. Should this status continue even if these countries continue to use it to shoot down any resolutions regarding themselves? What could be done to change it?
In an ideal world, no, it should not. It's a very unfair practice. It creates an international system which is completely imbalanced. It gives a lot of power to states which perhaps were powerful at the end of the Second World War. I'm specifically referring to France and UK, but their current status does not justify them having veto powers. Or for that matter, no country in the world should have a veto power. It creates a lot of problems. But having said that, is the world an ideal place? No, we are not living in a utopia. We use that within international relations, we use the term realist, real politics. That if you have power, you can perhaps get away with a lot of things. This veto power gives you that power. And that is the reason why India has taken a very specific stand. India says that there should be reforms at the United Nations Security Council. One of the first reforms is that there should be more permanent members. And these new permanent members, either all the permanent members give up their veto power, or if the current 5 permanent members are not ready to give up their veto power, then more countries should have veto power. It has an internal contradiction to the logic as well. I accept that. But what India is saying is that if a country like India also gets veto power, then at least there will be one country in the permanent 5 which can truly represent a lot of communities, a lot of countries in the world. We can represent, because we are a multicultural, multi-ethnic state, we can represent the African states, we can represent the states, we can represent the developing states, we can represent the global south. Something that China does not do, because China is still a country which progressively has an image of a country that does not respect international law. So ideally, no country should have veto power. But if the current 5 are going to continue with their veto power, then we should also have veto power. That's India's stand.
We'll take few more questions.
Yeah.
How strong are international laws related to sanctions, and despite the imposition of many sanctions on countries such as Iran and Russia, how are countries able to root them and turn them advantageous?
Okay. The first part of your question, international law is effectively silent on sanctions. As I mentioned earlier, the only clear permission to impose sanction belongs to an international organization, the United Nations. International law does not clearly allow, in an unequivocal manner, individual countries to impose sanctions on others. It doesn't do that. But the second part of the question, as I mentioned earlier, sanctions can only become important if the country which is imposing sanction is economically very strong and the country which is facing sanctions is economically very weak. So if America is putting sanction and the target is, let's say, again, the same example, Ethiopia, then the sanctions will be very successful. But if the country which is imposing sanctions is America, or let's say even the European Union, and the target country is Russia, the sanctions will not be very effective because Russia is not that weak. In the case of Iran, Iran is not that strong an economy to resist American sanction, but Iran has been very lucky because there are 2 countries which are standing with Iran. 2 countries, which is Russia and China, who don't like America. So the moment America puts sanctions, these 2 countries realize that Iran creates problems for America. So your enemy's enemy is my friend. They started promoting closer economic relations through investments, through bilateral trade negotiations with Iran in order to help Iran circumvent the American as well as United Nations sanctions. So if there is a country which is unfortunate enough not to have Russia or China or any other major economic power stand with it, then that country will definitely crumble under US or UN sanctions because their own economy won't be able to absorb the pressure. In this case, Iran has been lucky, and therefore Iran has turned it actually into an advantage. No country was ready to invest in Iran, but because of American sanctions, 2 years ago, China signed an agreement which will ultimately lead to investments close to $30 billion, which the Iranians are very happy about. And obviously, Americans are not. I hope that answers your question.
So one question that students are asking, and that's the most repeated question, which is, will BITS Law School will be developing a specialization in international policy?
In international policy, see, this is a part of the active discussions at the school level right now. I won't be able to give you a very clear answer because I don't know in which direction the decision making would go. But I can tell you this: the specialization is not going to be offered, and it can't be offered at the level of BLLB because it's a very, the statement is going to be grammatically a bit of problem. The specialization is quite specialized. It's a very niche area. You can't have that many non-hardcore law electives at the level of BA or BBLLB. So if a specialization in international law or in international policy law, international negotiations offered, it can only happen at the level of masters, at the level of LLM. and we are actively considering this. I'm a part of those negotiations. I've started these conversations with at least two of our faculty members who are specialists in law, and we are actively considering this.
This was the most repeated question, so I had to get further.
Yeah, I'm sure. I was expecting that question.
Yeah. So this last question goes, please educate us about Indian diplomats' zero tolerance on terrorism. Is it a part of India's new foreign policy?
Yes. Not new in the sense that it has not come up only in the last 5 or 6 years. At least from 2008 onwards, the infamous 26/11 Mumbai terror attacks, that's where the shift started happening. It has now become so deeply established that it seems that it's very visible now. But the zero tolerance for terrorism started becoming a part of the language used by our diplomats, and it became a part of our bilateral treaties. It became a part of our official statements right after the 26th November 2008 unfortunate attacks. In the last few years, we have had a lot of success, and that's why it has become more visible. So, for example, despite innumerable vetoes used by China, we have been able to get the United Nations Security Council impose a few restrictions and sanctions on Pakistan because of its state level support for international terrorists. How have we done it? We have presented evidence to the UN Security Council that these are the individuals who are actively engaged with terror groups which carry out strikes against India. And then we have also gone ahead and presented evidence that these individuals are present in Pakistan. So Pakistan can be accused of harboring terrorists. And we have used our diplomatic negotiating power with the UN Security Council members, with the exception of China, of course, to convince them to put sanctions on Pakistan. And this is why this is why the statement that Indian diplomats now have zero tolerance on terrorism, which is absolutely right. But I'll say that it's not now, it has been going on for the last 16 years at least. It has just started giving out more results in the last decade or last 5 years. But one of the pillars of our foreign policy is zero tolerance for terrorism. And a lot of these countries have started, a lot of Western countries have found have got a newfound respect for us. I can give you a specific example. In the case of US, see, India has been talking about terrorism from the days of terrorism in Kashmir, which started in 1989, 1990 onwards. But not a lot of Western countries paid attention to it. America started paying attention to it after the 9/11 attacks, terror attacks in the US in 2001, and the resultant foreign policy that US adopted, which was called the Global War on Terror, GWOT. And that's when India turned around and said that we have been saying the same thing for close to a decade. We need global collaboration, cooperation, and integration of resources to tackle global terrorism. And that's where the respect for Indian foreign policy and India's stand on terrorism started emerging. I hope that answers your question.
Yes, so I think we have taken a lot of questions. Majority of the questions have been answered, and the question especially about having specialization about this in our curriculum. So yes, so thank you so much, Professor Mushtaq, for such a beautiful session and throwing a light on about the Indian foreign policies and international law. So students, if you still have any questions regarding this, you can always drop us an email at admissions@bitslawschool.edu.in. We surely will try to get back with an answer from Professor Mushtaq to you about this.
My pleasure. And if I have students, prospective students in the list of participants, I look forward to seeing you soon. Take care. Good night. Bye-bye.
Thank you so much.
My pleasure. Thank you.